Good morning, everybody. Today marks the first day of the first session of the hearings of the Judicial Commission of Inquiry into allegations of state capture, corruption, fraud in the public sector, including organs of state. Mr. Paul Pretorius, the head of the legal team, will let everybody know what's going to happen today and in the next few days in terms of witnesses that will be called. But I would like to open with a few remarks in relation to the commission. As we all know, this commission was formally appointed on the 25th of January 2018 by way of a proclamation number 3 of 2018, published in the Government Gazette of 25 January 2018. Its background is well known to all of us. It was appointed pursuant to the remedial action taken by the public protector in terms of her report styled State of Capture, which was confirmed by the judgment of the North Gauteng High Court. As we all know, the report of the public protector was released in October 2016, and the judgment of the North Gauteng High Court was delivered in December 2017, and this commission was appointed in January. It is necessary to talk about the scope of the investigation that will be conducted by this commission. Its scope is to be found in the terms of reference, excuse me, in the terms of reference which were published in the Government Gazette to which I have just referred. This is necessary to remind everybody what this commission is about, and to remind all concerned too about the kind of information or evidence that will be relevant to the investigation of this commission, so that people who have that information or that evidence may come forward and give the commission information that is relevant to its terms of reference. The terms of reference of this commission are to the effect that this commission was appointed to investigate matters of public and national interest concerning allegations of state capture, corruption, and fraud. The terms of reference have 9 paragraphs or clauses which set out the scope of the investigation of the Commission. They read as follows. 1, the Commission shall inquire into, make findings, report on, and make recommendations concerning the following, guided by the Public Protector's State of Capture Report, the Constitution, relevant legislation, policies, and guidelines, as well as the order of the North Gauteng High Court of 14 December 2017 under case number 91139/2016. 1.1, that is the following that I've just referred to. Whether and to what extent and by whom attempts were made through any form of inducement or for any gain of whatsoever nature to influence members of the National Executive, including deputy ministers, office bearers, and/or functionaries employed by or office bearers of any state institution or organ of state, or directors of the boards of SOEs. In particular, the Commission must investigate the veracity of allegations that former Deputy Minister of Finance, Mr. Mcebisi Jonas, and Ms. Mentor were offered cabinet positions by the Gupta family. 1.2, whether the President had any role in the alleged offers of cabinet positions to Mr. Mcebisi Jonas and Ms. Mentor by the Gupta family as alleged. 1.3, whether the appointment of any member of the National Executive, functionary and/or office bearer was disclosed to the Gupta family or any other unauthorized person before such appointments were formally made and/or announced, and if so, whether the President or any member of the National Executive is responsible for such conduct. 1.4, whether the President or any member of the present or previous members of his National Executive, including deputy ministers or public officials or employee of any state-owned entities, SOEs, breached or violated the Constitution or any relevant ethical code or legislation by facilitating the unlawful awarding of tenders by SOEs or any organ of state to benefit the Gupta family or any other family, individual, or corporate entity doing business with government or any organ of state. 1.5, the nature and extent of corruption, if any, in the awarding of contracts, tenders to companies, business entities, or organizations by public entities listed under Schedule 2 of the Public Finance Management Act, number 1 of 1999, as amended. 1.6, whether there were any irregularities, undue enrichment, corruption, and undue influence in the awarding of contracts, mining licenses, government advertising in the New Age newspaper, and any other governmental services in the business dealings of the Gupta family with government departments and SOEs. 1.7, whether any member of the National Executive, and including deputy ministers, unlawfully or corruptly or improperly intervened in the matter of the closing of banking facilities for Gupta-owned companies. 1.8, whether any advisors in the Ministry of Finance were appointed without proper procedures. In particular, and as alleged in the complaint to the Public Protector, whether 2 senior advisors who were appointed by Minister Des van Rooyen to the National Treasury were so appointed without following proper procedures. 1.9, the nature and extent of corruption, if any, in the awarding of contracts and tenders to companies, business entities, or organizations by government departments, agencies, and entities. In particular, whether any member of the National Executive, including the President, public official, functionary of any organ of state, influenced the awarding of tenders to benefit themselves, their families, or entities in which they held a personal interest. Those are the terms of reference of this commission, which may be amended, varied by the President, should he consider it necessary to do so. It will be clear from the terms of reference of this commission that the scope of its work is wide, and that there is a lot of work that the commission needs to do. Today is only the first day of the first session of the hearings. There will be other sessions. We are hoping that we are going to have another session before the end of the year, and then we will have further sessions in the new year. As you know, over the past few months, the Commission has been hard at work trying to ensure that it can start its work and it would be ready for hearings as soon as possible. We are able to start today and deal with certain matters this week and in the next few weeks. We believe this session could take 3 weeks, but there is a possibility, depending on a number of things, that it could take up to 4, 5, or 6 weeks. Then there will be an adjournment, and we will then have another session before the end of the year. While the hearings are going on, the work of the Commission will be continuing by way of investigators. But I need to talk about some of the challenges that we have had as a Commission. You will be aware that in the previous media briefing, I alluded to the fact that we did have certain challenges in the process of security clearance, which is done by the State Security Agency. And I indicated then that this Security State Agency had not been able to meet our expectations and requests in terms of an expeditious processing of security clearance. I indicated at that time that I was going to be writing to the President to ask him to intervene, because previously he had indicated to me that if there were challenges, I should approach him. I did write to the President, and that was at the beginning of August. I think the letter was dated 1st of August. That letter was delivered. At this stage, or as of Thursday, the report I got was that there is not much that the state security agents had done in terms of expediting the security clearance processes. At this stage, if there's anything that has happened since then, it might have happened over the weekend or Friday over the weekend, but we as far as I know, we still have that challenge. And I hope that this will be resolved pretty soon, because we have already lost a long time. Already when we had the media briefing, we had quite some time when we were expecting the state security agents to fast-track some of these processes. We are hoping that it will be resolved, because the work that the Commission needs to do is urgent. We are constantly asked how far we are, and I have a team that is working day and night to try and make sure that the work of the Commission is given the urgent attention that it deserves. But the fact of the matter is that a commission such as this depends to a very large extent on government departments for certain things. It depends on the cooperation of government departments for many things. At this stage, there are ministers that we have had to deal with, and at ministerial levels, those that we have dealt with have been very supportive, have been very cooperative, but sometimes there are challenges with regard to officials. We have had some delays also in the dealings of the Commission with the National Treasury over the past few months, so much so that on 2 occasions I've had to ask the Minister of Finance to intervene so that there could be progress. And on 2 occasions, on each occasion that I've asked the Minister of Finance, he has given the Commission full cooperation, he has been supportive, and he intervened successfully so that progress could be made. We have those challenges. We hope that all concerned, including officials in various government departments, appreciate that this Commission needs full and proper cooperation from all of them. Indeed, the terms of reference of the Commission, as well as the regulations, make it quite clear that government departments must give full cooperation to this Commission. We are going to continue to do the best that we can, but I thought it was important to mention that for certain things, we really have to depend on other people. A few weeks ago, we issued a public notice where we invited the public, anyone who has information that is relevant to our investigation, who has evidence of allegations of state capture and corruption and fraud relating to the work that we are doing, having regard to the terms of reference, to come forward and give that information to the Commission. The response has not been what we were expecting. The response has been quite disappointing. I would like to take this opportunity to once again ask the public to please, if they have information, to come forward. We are everybody wants this Commission to finish this job as soon as possible. But obviously, if it is to do its job properly, it needs to have information. And we all know that there are many people out there and who have evidence and who know some of the things that were happening. But if they don't come forward, that doesn't help this Commission, and that doesn't help this country. This Commission is an opportunity for all of us in this country to play a role, to contribute to finding a solution to 2 very important issues to us as a nation. 1, corruption, 2, state capture. And of course, for purposes of this commission, the two are linked. State capture, if the allegations that we are going to investigate are proven to be true, includes individuals who may have decided that they would want to be able effectively to make decisions that should be made by constitutionally appointed functionaries of the state. That is something very serious. That is something that should not be allowed, and that's part of the reason why there is this commission. People in municipalities, people in provincial governments, people in national government, do they not have any information? Public representatives who serve in different capacities, members of the executive, national, provincial, do they not have any information? We urge all South Africans who love this country to come forward and assist this commission in order that we may resolve this problem. In conclusion, I just want to say the team attached to the commission and all the staff of the commission have worked very hard for us to be where we are today. If one compares the time taken by other commissions from the time they were appointed to the time they started having their first hearings, we are not doing badly. We have also done reasonably well. And it's because of the hard work of the legal team, officials of the commission, despite the delays that have happened, mainly because of the cooperation and support that we need from government departments. Thank you. At this stage, I think the head of the legal team, Mr. Pretorius, would want to make an opening statement.
Thank you, Chair. The opening address that I'm about to give on behalf of the legal team is the product of a consensus-building exercise that the legal team has adopted over the past few months that we have been about our work. And just like to take the opportunity, you know the legal team, Mr. Chairman, but may I introduce them for the purposes of the public? And I'll go from left to right in no particular order. Advocate Leah Kabashi, Advocate Thandi Norman.
Sorry, Mr. Pretorius. Is Mr. Pretorius audible right at the back? Okay, thank you.
Thank you, Mr. Chair. Advocate Maleka on the right, Advocate Mokoena, Advocate Sello, Advocate Buthelezi, and behind me, Advocate Malefe. Advocate Hofmeyer will attend next week, and attorneys Mabunda and Rob are also present assisting the legal team and the Secretariat respectively. Mr. Chair, the purpose of the opening address is really to explain to the Chair at this early stage how the evidence leaders understand their mandate, their role in the work of the Commission, and how they have planned and will plan to lead evidence before the Commission. The second purpose of this address is to ensure that at the outset we establish a mode of operation that communicates clearly and completely to the public, one of our most important constituencies, what this commission is investigating, the evidence that the legal team will present, and the issues that the legal team will traverse in its presentations to you, Mr. Chair. Firstly, the legal framework under which we operate begins with the constitutional provision that provides that the President is responsible for appointing commissions of inquiry. This commission has been appointed by the President, the former President, to investigate allegations of state capture, allegations of corruption, and allegations of fraud in the public sector, including organs of state. We are governed by the provisions of the Commissions Act of 1947. This act confers certain powers on the Commission as well as certain duties. The terms of reference which have been promulgated, to which you have referred, Mr. Chairman, bind the Commission and set out in more detail the matters which this Commission is obliged to investigate. And I will deal with the terms of reference in detail in due course, repetition notwithstanding, Mr. Chair. Regulations have also been promulgated. These govern the proceedings of the Commission. They also give the Commission certain powers, for example, to search premises and seize documents, but only on the authority of a warrant issued by a judge. The Commission has also issued and promulgated its own rules. These govern the proceedings of the Commission. In terms of all these instruments, Mr. Chairman, our hearings will be held in public, but in appropriate circumstances, hearings may be held in camera, that is, to the exclusion of the public. Arrangements have also been made for evidence led before you, Mr. Chair, to be transcribed and placed on the Commission website. In addition, the evidence to be led will be the product of the work of the investigations team and the legal team, acting together and in cooperation. However, as you have said, Mr. Chairman, we will also rely to a large extent on evidence provided by members of the public and members of government. And we note too, as you have, Mr. Chair, that term of reference 3 reads that all organs of state will be required to cooperate fully with the Commission, and we would expect no less. The role of the legal team then, in summary, Mr. Chairman, has been and is still to provide legal support to the Commission, particularly in setting up the Commission, to present the evidence obtained and prepared by the investigation team, or in certain cases by the legal team, to you, Mr. Chairman, and then to provide such assistance as we're able, Mr. Chair, in directing investigations and by compiling research and making submissions on findings and recommendations. As you have stated, Mr. Chairman, this Commission has its origins in an investigation conducted and a report issued by the former Public Protector. And that report, in its title page, reads that it was a report on an investigation into alleged improper and unethical conduct by the President and other state functionaries relating to alleged improper relationships and involvement of the Gupta family in the removal and appointment of ministers and directors of state-owned enterprises, resulting in improper and possibly corrupt award of state contracts and benefits to the Gupta's family businesses. The Public Protector made certain findings, but did not complete her investigation. That is now the task of this Commission. But the terms of reference of the Commission have widened the scope of the investigation materially, beyond that which the Public Protector dealt with. So, Mr. Chairman, the question arises, what, broadly speaking, is the scope of our investigation? The first issue is, how far back does this Commission go? More than one communication already made to the Commission raised the issue of the time period to be covered by the Commission. In particular, the question has arisen, how far back does this Commission go? That question has not yet been fully and finally answered by the Commission, and appropriately so. The Chair will obviously be asked by the legal team to consider submissions in this regard to the extent appropriate and when appropriate. The first approach to this issue, Mr. Chairman, is of course that the text of the terms of reference dictate what factual occurrences this Commission is required to deal with. These events have obviously occurred within a fixed time period. But there are more general terms of reference dealing with issues that are not restricted to a particular time period. For example, those terms of reference that require the Commission to investigate the nature and extent of corruption in state entities and at all levels of government. In this regard, perhaps a few remarks, Mr. Chairman. It is self-evident that the very essence of our Constitution, our 1996 Constitution, was to bring to an end a political system that had indeed been, in a word, captured by a government acting in the interests of a privileged minority at the expense of a disempowered, marginalized, and impoverished majority. Our terms of reference direct us, at least in the first instance, perhaps to a different period, and to at least arguably answer a different question. That is, has the state again, to a larger or lesser degree, been captured? Has it been possible, we will ask once again, to distort and manipulate state entities in such a manner and to such a degree to serve the interests of a privileged few? And, Mr. Chairman, we will, in our submissions, raise the issue about the significance of this question being asked now in 2018. How did this occur, and how could it occur if it did occur in a constitutional democracy post-1996? In other words, and in short, Mr. Chairman, the broader question signified by our terms of reference, read as a whole, may be asked: has the democratic project envisaged by our Constitution been derailed? And if so, can it be brought on track, and how? It bears emphasis, Mr. Chairman, that state capture, as you have stated, is not just about corruption. It is not even just about widespread corruption. Corruption may be part of state capture, but it is more than that. State capture, at least in theory, would, if proven, concern a network of relationships, both inside and outside government, whose objective would be to ensure the repurposing of government departments, officials, and state-owned entities, all for private and illicit gain. So, Mr. Chairman, the essential questions, and this by way of introduction, that the legal team will submit that the Commission should ask are the following. Firstly, is what occurred within the terms of reference a series of random and disconnected acts, or was it an organized and comprehensive manifestation of state capture? The second question, did what occurred concern not only acts of corruption, but also a deliberate weakening of constitutional government and a repurposing of constitutional state structures? In other words, was there, in our recent history, a deliberate attempt to weaken democratic processes and to shift political and policy decision-making away from constitutionally appointed and constitutionally accountable bodies? Did what occurred involve a systematic undermining of the country's laws and principles? Did this happen at the hands of a network of alliances between persons and entities, both inside and outside the state? And did what occurred, if it is found by you, Mr. Chairman, to have existed or to exist still, have as its goal the diversion of state funds and state resources into private hands? And if all that is shown, or all those questions are answered, at least to a degree, the further question which arises is, what is the impact of all that on constitutional goals, such as development, empowerment, service delivery, transformation, and redressing the inequalities of the past. The legal team, Mr. Chairman, will submit that the Commission might investigate circumstances where the allocation and distribution of state resources is determined or might have been determined by a network of persons outside and inside government, acting contrary to constitutional and legal norms, directed not in terms of our laws and policies, but for the private financial gain of members of that network, and facilitated by a deliberate effort to weaken key state institutions. A further question we may have to address as a legal team before you, Mr. Chair, is whether the existing legal framework, in fact, permitted a redirection of resources from state-owned entities and state entities into private hands in the manner found to have occurred. Put differently, the question may be asked, to what extent was the redirection of state funds and resources found to have occurred allowed by prevailing laws and policies? Dealing now with the approach to evidence that the legal team will adopt, Mr. Chair, it is necessary to pause a moment. It's important for the legal team to state before you, Mr. Chair, that this investigation can assume no facts. Any findings that we will put before you will have to be based on evidence led before you, Mr. Chairman, and the scope of that evidence will be determined by the terms of reference. So where the Commission, Mr. Chair, is asked to interrogate an issue, the legal team will not presume a particular outcome. Witnesses that we call before you may have different, even contradictory versions in relation to a particular allegation of fact or set of facts. And it is our function as a legal team to operate objectively and to explore all material and relevant versions. But, Mr. Chair, as you said at perhaps it was the first public gathering which you addressed for the first time in February this year, you outlined three major issues that the Commission would interrogate. Broadly speaking and in summary, firstly, did state capture ever exist in South Africa in the period covered by our terms of reference? Secondly, does state capture still exist in South Africa? And if the answer to these questions is in the positive, how can state capture be eradicated through policies and measures put in place to ensure that it does not reoccur, or at least ensure that the risk of it recurring is minimized? It bears emphasis, Mr. Chair, that the answers to all these questions, both general and specific, lie within the powers and duties of the Chair. It is the duty of the investigation team to find the evidence. The legal team's duties are to present the evidence and make submissions. Obviously, the investigation team and the legal team will work in cooperation. And as yet, no substantive findings have been presented to you, and no substantive findings, we understand, have been made. In the approach we will adopt, Mr. Chair, we will refer at the basis of our submissions and the basis of evidence to the constitutional state, and then question whether its institutions and laws have been undermined or manipulated. For the purposes of this presentation and later for our evidence and submissions, we will regard the constitutional state in at least two aspects. The first, on the left-hand side of that screen, the offices and institutions which are relevant to our inquiry, subject to what I will say below. And secondly, the backbone of laws, policies, and ethics that support that structure. So we have, and I will refer to this briefly in a moment, the three branches of constitutional state: Parliament, the National Executive, and the Judiciary. The National Executive, headed by the President, who appoints the Cabinet, who in turn would run or control the departments, and under their aegis, the SOEs and other state entities would operate. That whole framework of persons, officials, and institutions is governed by much legislation, and much more legislation than is apparent on the screen, and I'll refer in more detail to some of that in a moment. But for the moment, the Constitution, the Executive Members' Ethics Act and Code, the Prevention and Combating of Corrupt Activities Act, the Public Finance Management Act, and Treasury regulations are but a few of the relevant legislative instruments that we will refer to. So the evidence will recognize, Mr. Chairman, that there are indeed three branches of government. And each branch of government has an association with issues of alleged state capture. Parliament has conducted its own investigations into allegations of state capture. For example, various committees have been investigating allegations relating to financial mismanagement and governance at Eskom. The Department of Home Affairs, the Department of Mineral Resources, the South African Broadcasting Corporation, the Passenger Rail Agency of South Africa, and others have also been the subject of investigations. And many of the issues investigated are related to allegations of state capture. The judiciary, too, has dealt with many cases involving allegations of state capture in carrying out its tasks of interpreting and applying the law and imposing it on the executive and other state institutions. Obviously, these decisions bind this commission, and the most important of these, Mr. Chairman, is the one you referred to, the President of the Republic of South Africa versus the Office of the Public Protector and others, a 2018 decision of the full bench of the Gauteng Provincial Division.
I think that is 2017 you mean?
2017, yes.
Yeah, you said 2018.
Yes, I stand corrected. Thank you, Mr. Chairman. It's reported in 2018. Our terms of reference, Mr. Chair, focus then to a large degree on the executive branch of government. As the legal team understands the terms of reference, they mandate the Commission to investigate mainly the capture of and corruption in government institutions and state-owned entities. Thus, the focus of the legal team will be on executive government and state-owned entities, and not, at least in the first instance, the legislature or the judiciary. Our terms of reference do not take us there. Of course, this approach is subject to any finding that you may make, Mr. Chairman, and of course subject to any submissions to the contrary that may be placed appropriately before you. One of the first issues that we will deal with in evidence is the issue highlighted in the first terms of reference, and that's the issue of ministerial appointments and dismissals. We know, as a matter of law and practice, Mr. Chair, that the President in his discretion dismisses and appoints ministers. But it is not an entirely unfettered discretion in the submission of the legal team. In doing so, the President is bound in our submission by at least Section 96 of the Constitution, read with the Executive Members' Ethics Act and the Code. So, Section 96 of the Constitution states, Mr. Chair, that members of the Cabinet and Deputy Ministers must act in accordance with a code of ethics prescribed by national legislation. Section 96(2) reads that members of the Cabinet and Deputy Ministers may not undertake any other paid work. They may not act in a way that is inconsistent with their office or expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests, nor may they use their position or any information entrusted to them to enrich themselves or to improperly benefit any other person. The Ethics Code, which is informed by Section 96 of the Constitution and the Act, requires that the President and the Cabinet must always behave in the best interests of good governance, with integrity, in good faith, loyalty, and never in a way that is inconsistent with their position. They may not share privileged information, and they may not use their position to benefit themselves or to benefit other parties. The Public Protector, in her report, indeed highlighted aspects of the Code in relation to Cabinet appointments. And the Commission's terms of reference deal with Cabinet appointments and, in the submission of the legal team, related dismissals directly. And although this is somewhat repetitive, Mr. Chair, perhaps the repetition is understandable and perhaps even useful. Term of reference 1.1 reads, in particular, the Commission must investigate the veracity of allegations that former Deputy Minister of Finance, Mr. Nkabisi Jonas, and Ms. Mentor were offered cabinet positions by the Gupta family. The second term of reference related to this series of terms of reference requires the Commission to investigate whether the President had any role in the alleged offers of cabinet positions to Mr. Jonas and Ms. Mentor by the Gupta family as alleged. And the third related term of reference is somewhat broader. It reads, whether the appointment of any member of the National Executive, functionary and or office bearer was disclosed to the Gupta family or any other authorized person before such appointments were formally made and or announced, and if so, whether the President or any member of the National Executive is responsible for such conduct. In regard to these terms of reference, Mr. Chairman, the legal team will seek to lead evidence in regard to the following. Firstly, whether the alleged offers of cabinet posts were in fact made. For our task is to examine the veracity of evidence alleging that they were indeed made. Secondly, if so, whether the former President indeed acted unlawfully and improperly in relation to the appointment of members of Cabinet. And thirdly, whether third parties, for example the Gupta family, played an unlawful or improper role in Cabinet appointments, and if so, whether the former President was aware thereof. And if proven, the legal team will make submissions in regard to the extent that this conduct constitutes or might constitute a violation of provisions of the Constitution and indeed of the law. Mr. Chairman, in relation to these particular terms of reference, the legal team will also ask what further consequences ministerial dismissals and appointments might have had. For example, the question arises how these dismissals and appointments might have affected board and executive appointments at state-owned entities, what effect this might have had on governance at state-owned entities and other state entities, how procurement practices might have been affected by these appointments. Put differently, Mr. Chairman, were certain ministerial dismissals and appointments intended to further alleged state capture, and did they have this effect? Mr. Chairman, much of the evidence led before you in accordance with the terms of reference will deal with the issue of the allocation and distribution of state funds and state resources. We know, and it is trite, Mr. Chairman, that government departments and state-owned entities have the ability to procure goods and services on their own behalf and on behalf of the state. The object of that procurement, apart from the direct object of obtaining the goods and services, is to further, in our submission, constitutional principles and socio-economic objectives. There is a raft of legislation, together with constitutional provisions, that governs that procurement process, that governs the allocation and distribution of state resources. And some of those are listed on the right-hand side of that screen, and I'll deal with some specific aspects of that legislation in due course. But it is not only the Constitution, the Public Finance Management Act, and the related Municipal Finance Management Act, but also the Preferential Procurement Policy Framework, the Prevention and Combating of Corrupt Activities Act, the various pieces of legislation and policies governing state-owned entities, the Companies Act, and the fiduciary duties which are imposed on directors. One of the constitutional principles has been well expressed in an academic article by Peter Labuskaghni, where he states, one of the underlying values of the Constitution is to address and correct the imbalances of the past, to create a moral, just, and equitable dispensation. So, in the new democratic order, the state is regarded as the custodian of resources and income, and the state must ensure that these resources are channeled in such a way as to address socio-economic needs and social inequalities. I have referred, Mr. Chairman, to the legislation which governs the allocation and distribution of state funds and resources. Section 195 of the Constitution is instructive in this regard, and I apologize for the small print. Section 195 is worth having direct regard to in our submission, Mr. Chair. It states that public administration must be governed by the democratic values and principles enshrined in the Constitution, including the following principles. A high standard of professional ethics must be promoted and maintained. Efficient, economic, and effective use of resources must be promoted. Public administration must be development-oriented. Services must be provided impartially, fairly, equitably, and without bias. People's needs must be responded to, and the public must be encouraged to participate in policy making. Public administration must be accountable. Transparency must be fostered by providing the public with timely, accessible, and accurate information. Good human resource management and career development practices to maximize human potential must be cultivated. Public administration must be broadly representative of the South African people, with employment and personnel management practices based on ability, objectivity, fairness, and the need to redress the imbalances of the past and to achieve broad representation. Section 217 of the Constitution deals directly with procurement. It's also relevant and will be relevant throughout the evidence that we present to you, Mr. Chairman. It reads, when an organ of state in the national, provincial, or local sphere of government, or any other institution identified in national legislation, contracts for goods or services, it must do so in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. Subsection 1 does not prevent the organs of state or institutions referred to in that subsection from implementing a procurement policy providing for categories of preference in the allocation of contracts and the protection or advancement of persons or categories of persons disadvantaged by unfair discrimination. And then reference is made in Section 217 to national legislation. So, Mr. Chairman, we return then to the first part of our terms of reference, particularly term of reference 1.1. The general introduction to term of reference 1.1 reads, and requires us to present evidence to you, Mr. Chair, as to whether and to what extent and by whom attempts were made through any form of inducement or for any gain of whatsoever nature to influence members of the National Executive, including deputy ministers, office bearers and or functionaries employed by or office bearers of any state institution or organ of state or directors of the boards of SOEs, state-owned entities. In our submission, Mr. Chair, term of reference 1.1 is at the heart of allegations of state capture. It requires the Commission to investigate whether, at least in the first instance, outside third parties, that is, persons who do not form part of government and are not accountable as government, attempted to influence improperly members of the National Executive, office bearers, and employees of state institutions and organs of state, and state-owned entities, directors and executives, and all this presumably for unlawful gain. Of course, Mr. Chairman, carefully read, it is not only outside third parties who might be guilty of conduct referred to in 1.1. Conceivably, one member of government may also improperly influence another member of government. We move on then, Mr. Chair, to term of reference 1.4, which reads and enjoins this Commission to deal with, by way of evidence and investigation, whether the President or any member of the present or previous members of his National Executive, including deputy ministers, or public official, or employee of any state-owned entity, breached or violated the Constitution or any relevant ethical code or legislation by facilitating the unlawful awarding of tenders by SOEs or any organ of state to benefit the Gupta family or any other family, individual or corporate entity. And we stress there the words, or any other family, individual or corporate entity doing business with government or any organ of state. As is apparent, Mr. Chairman, this term of reference focuses on the unlawful diversion of state resources and finances away from their intended beneficiaries and objectives and to individuals and companies and entities who would have had no lawful right thereto. In other words, for private and illicit gain. There are some examples, Mr. Chair, of evidence that is under preparation and that will in due course be presented to you, and these bear mention. The legal team will lead evidence on and submit that this Commission should investigate who the intended beneficiaries were of any unlawful award of tenders. Amongst those beneficiaries might be the Gupta family and their associated entities. Organizations such as Trillion and regiments may also have been involved. The legal team will also submit that the Commission should investigate whether persons inside the state or persons related to them could be included amongst those beneficiaries. And it may be that the purpose of distributing financial benefits was not only for direct financial gain, but also to maintain power and influence in regard to any proven state capture manifestation. So under this head, Mr. Chairman, the legal team will ask that the Commission investigates, amongst other things, state-owned entities, their procurement practices, and in particular, a number of alleged illicit transactions. For example, again, Mr. Chairman, there has been some work done in relation to allegations that at Eskom there was a deliberate effort to favour the Gupta family in the awarding of coal supply concessions. At Transnet, there are allegations that locomotive supply contracts were also inappropriately awarded after bribes were allegedly paid to Gupta-related parties. And at Denel, it is alleged that inappropriate joint ventures were being set up that would have resulted in significant profits from arms supply contracts being diverted unjustifiably to Gupta-related companies. These are all subject to investigations, subject to evidence, subject to your findings and submissions. The legal team, Mr. Chair, will also submit that the Commission should, when dealing with state-owned entities, examine contracts allegedly unlawfully induced and executed for private and illicit gain, also at a collective level. The Commission might examine the timing of these contracts, their frequency and size, the manner in which they were concluded, and in particular the persons and entities involved and the relationships between them. This in order to determine whether these individual contracts themselves were or were not part of state capture or remain part of state capture. In this particular aspect of its investigation, Mr. Chair, the legal team will submit to the Commission that it might ask whether the incidents and extent of corruption shown were directly or indirectly linked to cabinet appointments, appointments of boards of state-owned entities, appointments of state-owned entity executives, and appointments of procurement officials. Were these contracts and their execution, to the extent proven, linked to a failure of governance at all levels of executive government? In short, the legal team will request the Commission to investigate whether these contracts are the result of undue influence exerted for unlawful gain. This again will be covered by term of reference 1.1. The legal team will also ask, Mr. Chair, that the Commission investigate entities other than state-owned entities where the same patterns emerge, and will ask whether similar conclusions could feasibly be drawn about state capture and its manifestations. For example, the Free State Department of Agriculture is alleged to have made unjustified payments in relation to the Estina Dairy Farm project, where the actual beneficiaries may have been third parties not entitled to such benefits, including Gupta-related entities. Term of reference 1.6 Mr. Chairman, enjoins the Commission to investigate whether there were any irregularities, whether there was undue enrichment, corruption, and undue influence in the awarding of contracts, mining licenses, government advertising in the New Age newspaper, and any other governmental services in the business dealings of the Gupta family with government departments and SOEs. Of course, Mr. Chairman, it is obvious that unlawful tender procurement is not the only manner in which state resources and funds may be diverted away from their intended objects and for private and illicit gain. There are other means of misappropriation that the Commission will be asked and indeed is required to investigate. For example, the alleged diversion of the state advertising budget to the New Age newspaper and the television channel ANN7, the corrupt or irregular awarding of government contracts, mining licenses, and other government services, for example, airport landing rights or immigration facilities. What is instructive about this term of reference, however, Mr. Chair, is that it focuses solely on the Gupta family, unlike other terms of reference which are broader and refer to other families or entities. Term of reference 1.7 deals with an allegation that the Gupta family and Gupta-owned companies received, at least at an attempted level, some form of protection from the national executive. The term of reference requires the Commission to investigate and the legal team to lead evidence on whether any member of the national executive, including deputy ministers, unlawfully or corruptly or improperly intervened in the matter of the closing of banking facilities for Gupta-owned companies. This is a discrete term of reference, and it requires the Commission to investigate, in summary, whether the national executive or any member thereof unlawfully, corruptly, or improperly intervened to prevent private banks from closing Gupta company bank accounts. Term of reference 1.8, Mr. Chairman, deals with the issue of whether any advisors in the Ministry of Finance were appointed without proper procedures. In particular, and as alleged in the complaint to the Public Protector, whether two senior advisors who were appointed by Minister Des van Rooyen to the National Treasury were so appointed without following proper procedures. This too, Mr. Chair, is a relatively discrete term of reference. It deals with the appointment of advisors by Minister Des van Rooyen, allegedly without following proper procedures. Of course, the appointment of advisors by a minister rests entirely in our submission within that minister's discretion. The legal team will ask the Commission, however, to investigate the following issues. What procedures needed to be followed in respect of such appointment? Were they followed? And significantly, a related question, was Minister van Rooyen even aware of their appointments? It bears repetition that the legal team will in all cases, Mr. Chairman, request the Commission to investigate whether, to the extent proven, isolated incidents were or are part of a larger undertaking, with each part playing its deliberate and intended role. That brings us, Mr. Chair, to two discrete terms of reference dealing with the nature and extent of corruption referred to in term of reference 1.5 and the nature and extent of corruption referred to in term of reference 1.9. Term of reference 1.5 carries our own emphasis, talks of the nature and extent of corruption, if any, in the awarding of contracts, tenders to companies, business entities or organizations by public entities listed under Schedule 2 of the Public Finance Management Act as amended. This term of reference, may be noted, Mr. Chair, differs somewhat from the strict state capture theme contained in the other terms of reference. And if one goes back to the heading of the terms of reference, one reads, as has been pointed out both by yourself, Mr. Chairman, and by the legal team, that the Commission is required to investigate state capture, corruption, and fraud. So the legal team will submit that the Commission is enjoined to deal with corruption and fraud, which does not necessarily constitute state capture, and this is highlighted in these two terms of reference. The requirement here on the understanding of the legal team is not to investigate only or even all specified and individual acts of corruption, but rather to focus on their cumulative nature and extent. This term of reference is extremely wide, as you have pointed out in relation to the terms of reference generally, Mr. Chair. It requires investigation into the award of tenders by public entities listed under Schedule 2 of the Public Finance Management Act, and there are some 21 Schedule 2 institutions. They include the Airports Company, they include Arms Corps, they include the Central Energy Fund, they include Denel, the Development Bank of Southern Africa, Eskom, they include South African Airways, the Central Energy Fund, the South African Broadcasting Corporation, South African Express, the South African Nuclear Energy Corporation, Telkom, and Transnet Limited. A vast amount of work then would require to be done in this regard. Term of reference 1.9 is in similar terms, but has a qualification. Term of reference 1.9 requires investigation and recommendations in relation to the nature and extent of corruption, again our emphasis, if any, in the awarding of contracts and tenders to companies, business entities or organizations, in this instance by government departments, agencies and entities. And the qualification, which in our submission, Mr. Chair, does not limit the general introductory part of the term of reference, reads in particular whether any member of the national executive, including the President, public official, functionary, or any organ of state, influenced the awarding of tenders to benefit themselves, their families, or entities in which they held a personal interest. So it will be noted, Mr. Chairman, that the first part of this term of reference is worded in the same way as the first part of term of reference 1.5, and accordingly similar considerations to the interpretation and application of term of reference 1.5 apply to term of reference 1.9. But in this case, it is submitted that the Commission is directed to investigate contracts and tenders awarded by, firstly, government departments at a central level, government departments at a provincial level, government departments at a municipal level, government agencies and government entities. As far, Mr. Chairman, as terms of reference 1.5 and 1.9 are concerned, the legal team will in due course submit to you, Mr. Chair, that a thorough analysis of the nature and extent of corruption in public entities and at all levels of government should be investigated. This will no doubt involve expert research and analysis of such a nature that will enable the Chair of the Commission to formulate recommendations for remedial action. The legal team may, in this regard, submit at the appropriate stage to the Commission that it might need to draw on existing expert research. The legal team will also, Mr. Chairman, where necessary, suggest to the Commission that it might initiate its own investigations into public entities and government entities in order to better understand what made some organizations or parts of organizations more vulnerable to corruption than others, to investigate what structures and processes have proved better able than others to withstand the corrosive effects of corruption. The question remains, are there some general lessons, Mr. Chair, to be learnt that can inform a wider project of government renewal? Mr. Mr. Chair, I see it's 11:15. Would this be appropriate time? I have some way to go, but not very long.
I think it would be the appropriate time. We'll take the short tea adjournment. It's now 11:15. We'll be back at 11:30.
Thank you, Mr. Chair.
Thank you.
Okay, there you have it. That was, Advocate Paul Pretorius from the legal team. He was giving the opening address, basically giving the purview of the commission. Before that, you heard from Deputy Chief Justice Zondo, who heads the state capture inquiry, giving us the background of the inquiry. We'll have much more after the break. Stay with us.
61 now. Yeah, China mark.
Start at past, we will start at past. Thank you, Mr. Pretorius. Proceed.
Thank you, Mr. Chair. If I may, Mr. Chair, I'd like to deal with a general topic before proceeding further and dealing with the particular witnesses and evidence to be led. And it's to do with a theme that will pervade the presentations made to you in evidence and the submissions in due course to be made before you, Mr. Chair. And it deals with the essence of constitutional democracy and its potential breach, which may be referred to in evidence and may require submissions and findings in due course. And in our submission, Mr. Chair, the essence of a representative democracy, and in particular a constitutional democracy such as ours, is that the people entrust to the lawmakers, entrust to the executive, and entrust to the judiciary the responsibility to act in their best interests. And in particular, they should be held accountable if they fail to do so. In summary, and again I refer to the article by Peter Labuskaghni, the essence of representative government is that the elected government acts in the interests of those that it governs. Essential to that relationship is that officials can be held accountable when they fail to act according to this obligation. And in particular, they can be called to account if they act fraudulently and corruptly. We will submit in due course, Mr. Chairman, that the ability of the populace, the people in general, to hold an elected government accountable depends in large measure upon them being properly informed and upon them receiving proper and accurate information. It also depends on people being held criminally accountable for unlawful acts. Part of what this commission will be asked by the legal team to examine, Mr. Chairman, is whether there were attempts to take control of the public narrative and discourse, and if so, whether this was a manifestation of state capture in South Africa. What, the question will be asked, was the role of the New Age newspaper? What, the question will be asked, was the role of Bell Pottinger? Did the state, it will be asked, support the New Age newspaper? And if so, why? To the extent that such support might be shown, the further question is, was this simply to allow individuals and entities access to state funds, or was it to do with the control of the public narrative, or was it to do with both? And very importantly, a theme that will be explored throughout is, have any wrongdoers that might be shown to be such been held to account both within and outside of government? To the extent that the Commission may find that they have not been held to account, further questions can be asked. Is this inefficiency, or is it the result of some other cause? Or, possibly, is it also a manifestation of state capture? The question arises, will it be necessary to call our government and its law enforcement agencies to account as well? Returning to the terms of reference then, Mr. Chair, it is to be noted that these terms of reference may be added to, varied, or amended from time to time. That is the prerogative of the President. The legal team may well make submissions to the Chair in this regard, when and to the extent necessary and to the extent appropriate. I'll get to the next slide. Thank you. Dealing then with the final stages in time and the findings, report and recommendations as dealt with in the terms of reference. The first part of the terms of reference place various obligations on the Commission. It shall inquire into it shall make findings, it shall report, and finally make recommendations. Term of Reference 7 expands on this duty to a degree and records that the Commission shall, where appropriate, refer any matter for prosecution, further investigation, or the convening of a separate inquiry to the appropriate law enforcement agency, government department, or regulator regarding the conduct of certain persons. Mr. Chairman, it is clearly too early to state with any certainty what the investigations will produce, the detail and extent of the evidence that will ultimately be led, and therefore what submissions the legal team will make to the Chair. But what can be stated with a reasonable degree of certainty is that the legal team submissions in regard to the findings, report and recommendations that the Chair might make will address the following questions. And in the summary, I repeat, Mr. Chair, some of the questions referred to earlier on in this address. Firstly, did state capture exist? Does it still exist in the second place? If so, how can it be dealt with? Has the evidence shown a series of isolated or disconnected occurrences? Or has the evidence shown an organized and comprehensive plan that could be labeled state capture and that has informed all or some of these occurrences? Sixthly, has the full extent of any plan of state capture and its implementation been proven? Seventhly, to the extent that harm has been done to the state, to government, to state entities and state-owned entities, can that harm be remedied? If so, how? Lastly, what can be done both in the short term and the long term to prevent a recurrence of what might be found to have occurred and the effects that it might be found to have had? Is prosecution of offenders enough, or is more required? Should consideration be given to legislative amendments, to policy review, to restructuring and reorganization in public entities and their governance? Do provisions regulating procurement need overhaul? Or is it the persons rather than the processes that might be found to be at fault? If the processes are not at fault, how can compliance nevertheless be ensured? In regard to accountability, we might mention briefly that, of course, our criminal law deals with wrongdoing mainly through the prosecution of individual criminal wrongdoers. However, wrongdoers, if found to have acted in concert, may also be called to account as a collective. The Chair, Mr. Chairman, will no doubt in the future consider reference for prosecutions, further investigations or separate inquiries, and these may, if appropriate and in appropriate submissions and in appropriate circumstances, include the power to make use of the provisions of Section 204 of the Criminal Procedure Act in appropriate circumstances. And very briefly, Section 204 of the Criminal Procedure Act directs that if witnesses answer frankly and honestly all questions put, they shall be discharged from prosecution with regard to the offence so specified and with regard to any offence in respect of which a verdict of guilty would be competent upon charge of relating to the offence so specified. Now, of course, Mr. Chair, this Commission has no power to direct the use of Section 204, but if the Commission has the power to direct prosecutions, perhaps in appropriate circumstances, it might be persuaded by whomever concerned in an appropriate circumstance to recommend the lesser remedy provided for in Section 204. But again, it must be stressed that no decisions have been made in this regard, and it's all subject to appropriate submissions and appropriate consideration by yourself, Mr. Chair. At the stage that factual evidence is complete then, Mr. Chair, the legal team may be asked by the Chair to lead expert evidence on recommendations, particularly in relation to terms of reference 1.5 and 1.9, the nature and extent of corruption as has been dealt with above. or it may lead such evidence on its own initiative. Dealing now briefly and in summary, Mr. Chair, with the evidence actually to be led in the next few weeks. Later today, Advocate Norman will make a presentation dealing with reports already received by the Commission and in the public domain. A summary of the content of these documents and the basis of their admission will be dealt with by Advocate Norman. These reports may be admitted for what they are and dealt with in evidence, particularly to the extent that evidence is necessary to deal with any controversy that may be contained on a factual basis and otherwise in these reports. Over the past few years, and these will be dealt with in detail, Mr. Chairman, there have been a number of reports and studies into allegations of state capture. These include the Public Protector's Report, Parliamentary Committee reports, reports commissioned by Treasury, reports commissioned by state-owned entities and others. The Commission may be asked to have some regard to those reports, but the legal team will not, without further evidence, hold them out as being correct. The legal team may propose that the Commission should not undertake work which will be a repetition of work already done, particularly where there is little or no controversy in relation to facts found and conclusions drawn. But, Mr. Chair, where there is controversy or possible controversy, the legal team, together with the investigation team, will inevitably have to do its own investigative work, and thereafter the Commission will be asked to make its own findings. There will also, towards the end of next week, Mr. Chairman, be some expert evidence, by your leave, in relation to state capture as a concept generally. We know, Mr. Chair, that state capture is not a concept or practice unique to South Africa. As will be explained in the evidence of experts, the phenomenon has manifested in the past in many other countries, still does. It has manifested too in countries which may be described as democracies in transition in particular. Experts will deal with these phenomena. A particular expert may be called more than once, and more than one expert may be called to deal with the various aspects of the Commission's work in this regard. But we stress, Mr. Chair, that the fact that reference will be made to state capture in other democracies, particularly those in transition, is not to diminish its significance in South Africa. On the contrary, we may learn from a comparative analysis. Its prevalence and the apparent ease with which it appears in other democracies may sharpen our own vigilance in South Africa. We will also be assisted by the experience of other countries who have had to deal with state capture, with their successes and with their failures. Then there will be evidence on procurement, Mr. Chairman, and that will take place this week. The legal team, Advocates Thandi Norman, will seek to lead the evidence of the Acting Chief Procurement Officer of National Treasury. The purpose of this evidence will be to place before the Commission matters relating to procurement prescripts and policy. Procurement prescripts and policies will be submitted, central to the Commission's terms of reference. Some of the questions which the legal team will in due course seek to deal with are, firstly, is the procurement framework prevailing in our country comprehensive and adequate? Is it possible to manage the existing system in such a way as to prevent abuse? Has state capture, insofar as it might be shown and proven, been enabled or permitted by weaknesses in the procurement framework? Simply put, Mr. Chair, is it the people or the policies or both? And how best are any shortcomings in the procurement framework and its management addressed? Mr. Chair, if I could introduce the first one. An interactive slide that will ultimately appear on the Commission website, which fundamentally outlines the structure of the executive from the President to boards and executives of departments and state-owned entities, particularly state-owned entities. The legal team will commence leading evidence on the issues raised in items 1.1, 1.2, and 1.3 of the terms of reference. The witnesses will be led by Advocate Mokoena, Advocate Sello, and myself. The witnesses to be called will be Ms. Mentor, Mr. Jonas, Minister Neni, Minister Gordhan, and others. It will deal with the alleged undue influence by private interests in relation to the President and Cabinet appointments. What should be noted in this regard, Mr. Chair, is that this evidence will not necessarily be entirely consistent. Our mandate is not to prove a particular version of events. Our mandate is expressly to investigate the veracity or truth of allegations relating to Mr. Jonas and Ms. Mentor. The resolution of disputes of fact that might emerge falls within the province of the Chairperson. The legal team is also of the view, Mr. Chairman, that appointments cannot be properly interrogated and understood without having regard to their preceding dismissals and the circumstances in which these took place. These matters, too, will be covered in evidence. As stated, Mr. Chair, item 1.6 of the terms of reference covers a range of issues. It deals with the illicit provision of government services in favour of private interests. The team leading the evidence under this head is led by Advocate Maleka and includes Advocate Hofmeyr and others. Amongst the issues that will be dealt with in this session, Mr. Chair, and there will be other issues dealt with later, is the alleged attempted and actual appropriation of government advertising budget for the benefit of the New Age newspaper and possibly the ANN 7 television channel too. The legal team will also seek to present evidence of a witness from Government Communication Information System, and that witness will testify about the value structure of the institution from its inception to date, the procurement processes within the institution, and how those values and processes were allegedly undermined when the institution fell under the jurisdiction of Minister Mutambi. Then we will deal in this session too with protective steps taken, perhaps unlawfully, perhaps corruptly, perhaps improperly, perhaps all three, in relation to members of Cabinet or Cabinet interfering in the attempts by private banks to close bank accounts of Gupta, the Guptas, Gupta Associates, and Gupta-related companies. The question we are required to answer, or to lead evidence in respect of, is whether any minister or deputy minister acted unlawfully, corruptly, or improperly in intervening when several banks closed or sought to close the bank accounts of the Guptas or Gupta-related companies. Then we will get to phase 2 of the Commission's work. Evidence would be led at a later stage in this Commission's proceedings by your leave, Mr. Chair. And this work will hopefully enable the Commission to benefit directly from the work of the investigation team recently appointed and under the direction of Terence Nombembe. There are, Mr. Chair, a number of state-owned entities whose affairs the terms of reference require in the submission of the legal team the Commission to investigate and lead evidence on. These include Eskom, that team will be led by Advocate Maleka; Transnet, that team will be led by myself; Denel, that team will be led by Advocate Kabashi; South African Airways, that team will be led by Advocate Hofmeyr; the South African Broadcasting Corporation, a team led by Advocate Norman; and the Public Investment Corporation, team led by Advocate Buthelezi. There will be others as well. The Free State Vrede Dairy Farm issue, sometimes referred to as the Estina issue, will also be dealt with under the management of Advocate Kabashi. together with certain other issues in provinces and municipalities. Many of the issues relating to, for example, state-owned entities are already in the public domain, as will become apparent when Advocate Norman addresses you. We will, of course, not ignore this information as a legal team, Mr. Chair, but the investigations will no doubt not be limited to information at present in the public domain. And in relation to state-owned entities, government departments, procurement, and the alleged diversion of state resources from its intended goals to elicit private interests involves a number of discrete issues that need to be dealt with. And these matters might include, but not limited to, Mr. Chair, alleged undue interference in the appointment of state-owned entity boards and executives, alleged breaches which might have resulted in standards of corporate governance, and ultimately alleged irregular procurement practices. To the extent that procurement irregularities have resulted in financial loss or prejudice, the legal team will seek to present to the Commission evidence related to the extent of that loss if proven, and the extent to which the socio-economic objectives enjoined by the Constitution have been undermined or simply not met. As far as recommendations are concerned, the legal team will consider submissions to the Chair in regard to ensuring proper corporate governance and in particular recommendations relating to procurement management. Mr. Chair, I've already dealt with requirements placed on the Commission by terms of reference 1.5 and 1.9. As already stated, in the view of the legal team, there's a clear need to rely on detailed research and detailed commentary. As already stated, the Commission will of course conduct its own research and investigations and into corruption generally in Schedule 2 institutions and at all levels of government. But in our view, the reliance on research conducted or to be conducted outside the Commission cannot be underestimated. In the view of the legal team, the Commission will, in addition, no doubt require expert assistance in regard to recommendations in dealing with the findings that might be made in relation to corruption generally. Then to conclude with a few remarks, Mr. Chairman. It may appear from what the legal team has put before you thus far that the work of the Commission is intended only to uncover alleged wrongdoing on the part of persons within government and persons outside of government, and to ensure that they are called to account for their alleged deeds insofar as such may be proven before you. But to regard the work of the Commission in this light alone would be to ignore at least one of its more important aims, Mr. Chair. In the leading publication on public inquiries by Beer QC, references given, the learned authors highlight a major purpose of a public inquiry as being to restore public trust and confidence in government. To the extent that this Commission might show that this country has been beset by the phenomenon of state capture, the obvious demand on the Commission will be to recommend what needs to be done to address such a finding. Mr. Chair, experts on state capture that we have consulted thus far tell us that South Africa is exceptional amongst post-colonial democracies in the manner in which the international phenomenon of state capture has been responded to by our judiciary, by aspects of government, by our Chapter 9 institutions, by civil society. It is exceptional in the way that this phenomenon has been responded to. It's exceptional in the way it has been and continues to be investigated and dealt with. So if in continuing this work, viable solutions can be examined and proposed in its recommendations, Mr. Chair, we submit to you that this Commission can indeed play a positive role, not only for South Africa, but internationally as well. that is the legal team's opening. Thank you.
Thank you very much, Mr. Pretorius, for that opening statement. You indicated that the next item would be the presentation of reports, if I remember correctly, by Advocate Norman. Is that correct?
Yes, subject to one qualification, Mr. Chair, and that is that there are various legal teams eager to place themselves on record, and perhaps you may consider a short adjournment to consider that. Mr. Maleka will be dealing with this aspect of this morning's proceedings, and I'm not sure whether you would want to meet these teams in chambers prior to continuing to allow them to place themselves on record, or how you would wish to deal with it.
Do you know how many there are in terms of...
Chair, there are many. My respectful suggestion is that before you even meet them in chambers or otherwise, invite them to place their names on record, who they appear for, and what sort of directions they may invite you to make with reference to the interest they represent.
Mr. Pretorius, maybe it would be better to let them come forward and say what they are asking me to do. And once I have an idea, then maybe I can meet them in my temporary chambers here without when they indicate what they would like me to do for them or their clients. At this stage, I'm not asking for any elaboration. I would be wanting just an indication. I think maybe let's do that. Do you have something to say about taking that direction, Mr. Pretorius?
No, as you please, Mr. Chair. I would just suggest that we adopt the court procedure to avoid chaos of legal representatives introducing themselves in order of seniority.
Well, I think I'm going to then say, let me take an adjournment now, and Mr. Maleka, Mr. Pretorius, or the Commission's legal team, or some of them, can then bring those legal teams over to my chambers so they can introduce themselves first, and then we'll take it from there. We will come back here.
Yes.
Is that
Thank
fine?
you.
Yes.
Sure.
So we'll take a short adjournment now, and it should take not more than 10 minutes. Thank you. We adjourn. Mr. Pretorius.
By your leave, Mr. Chair, Advocate Maleka will deal with the next session of proceedings.
Thank you. Mr. Maleka.
Thank you very much, Chairperson. As we have indicated to you in chambers, There are several of our colleagues who appear for a number of individuals who have been implicated or may well be implicated by witnesses who are going to testify before you in the next several days. All of those persons have been given notices in accordance with the requirements of Rule 3 of the rules regulating the proceedings of the Commission. And they have indicated that they'd like to make some submissions to you in order to make directions regarding their right, if any, to cross-examine witnesses who may be testifying before you, and also any choice or election they may make in regards to filing their own opposing sworn statements and or their right to testify in person with or without additional witnesses. Subject to your direction, I would like to invite you, Chair, to invite those of our colleagues to place their names on record and indicate who they represent, and also indicate to you what sort of directions they would like you to make. I know that one of them, Mr. Chair, is Mr. Mike Helens, and perhaps he should start, not only because of his color or seniority, but the enthusiasm with which he indicated that he'd like to lead this part of the discussion on behalf of the implicated individuals.
Thank you. I've had discussion with the legal representatives of various parties in my temporary chambers here. May I invite you, maybe in the order in which you spoke in chambers, to come forward and place yourselves on record and indicate what you would like to say, and maybe Mr. Pretorius might wish to remove the file there. Thank you.
Is this on or not? Yeah. Thank you, Mr. Chairman. My name is Michael Helens, Senior Counsel of Johannesburg. I appear together with Mr. David Joubert SC, instructed by Rudy Krauser of BDK Attorneys on behalf of Mr. A.J. Gupta. But I do so in relation to the Rule 3.3 notices served on the 6th of August in respect of the evidence of Ms. Faiki Mentor and Mr. Temba Maseko. They were left at the gate of the Saxonwold residence of Mr. A.J. Gupta. I do not appear in respect of the evidence or implications of the evidence of Mr. Tebisi Jonas. I also represent with the same team Mr. A.J. Gupta in respect of any other allegations that may be made, and we've heard a wide-ranging and very able introduction by Mr. Pretorius on the length and breadth of that which is going to be dealt with in this commission. It would appear to us that we may be due a number of other 3.3 notices, but at the moment we just have those two. And as indicated in chambers, we would invite the evidence leaders to engage with us and to give us such notices as soon as possible. To sketch the background or the introduction to our appearance here is that naturally, as with the rest of the nation, we've known that the Commission would start, but when and how and what the mechanics would be were not known to us until at least the 3.3 notices were served, the Rule 3.3 notices were served, and in part also the able address of Mr. Pretorius. So now the planning from our side can ably begin, but the rules, as you're aware and the public should know, require us firstly to be given reasonable notice, and we know, sir, that the Commission had to start somewhere, somehow, and you've done a lot of work in being ready to prepare. So we make no complaint of what is technically short notice. We simply propose to put in place, by, if you'll give us leave to negotiate with the evidence leaders, a reasonable time frame in which to deal with the evidence. At the moment, I'm speaking in relation to the evidence of Faiki Mentor and Mr. Maseko, but I speak also broadly to my learned friends on my right and left in relation to such future pieces of evidence that may call for cross-examination or evidence from our clients. So the notices state that the witnesses will give evidence at the hearing commencing on 20 August, but we know that this is the commencement and not necessarily the date on which all these witnesses will give evidence. It appears to us that whatever the plans are of the Commission need not be interfered with by our temporary and justified lack of readiness, because the witnesses, in our respectful view, can still give evidence in terms of the planning of the Commission, because transcriptions will be available and no doubt even video facilities might still be available. So we would not interfere with the program of the Commission in relation to when the evidence is led, but we would ask that we make practical arrangements, not aimed at delay, merely to get ready in terms of the rules, to present cross-examination and to present such affidavits or evidence as we are required by the rules to file, in order for you to exercise your decision-making powers in relation to the range of cross-examination, the nature of evidence, and the differences between what the Commission is leading and what we might want to put forward. But for that, we do need a little time. We've discussed that broadly already in chambers, and I'm sure my learned friends and I and my team will reach accommodation with each other. Just a slight correction without starting the war. We have not been given due notice, as Mr. Maleka said, under the rule. It's actually quite short notice, but we make no complaint about that. And in a nutshell, we would ask for time to make appropriate arrangements for us to represent our client, at this stage Mr. AJ Gupta, in relation to the two raised issues. But at the same time, we indicate publicly and to my learned friends, if there are other issues, please give us time as notice so that we do not delay the proceedings of this inquiry. Our suggestion, just to think about, is given the demands on our time in relation to our own practices and prioritizing being ready, we believe we would be ready to cross-examine by the first week of September at the latest, but the actual detail we'll deal with the evidence leaders, subject to your decision, sir. Thank you.
Thank you very much, Mr. Helens. Thank you.
Thank you, Mr. Chairman. My name is Dawie Huber. I'm a member of the Johannesburg Bar. I confirm that I appeared together with Mr. Helens as he set out, and we obviously echo his sentiments.
Would you please just raise your voice a little bit? It's rather soft.
I also am instructed by Peter van der Merwe, attorney, to appear on behalf of Mr. AJ Gupta in relation to the evidence which Mr. Jonas might give. We are awaiting instructions on behalf of Mr. Duduzane Zuma and Mr. Rajesh Gupta with regard also in relation to the evidence of Mr. Jonas. Hopefully by early next week we will get clarity on that. Similarly, the Section 3, or rather the Rule 3.3 notices were only served in respect of Mr. AJ Gupta and Mr. Rajesh on the 13th of August, incomplete, and that of in respect of Mr. Duduzane Zuma was only served on the 14th according to the instructions. Thank you, Mr. Chairman.
Thank you. In terms of what should happen, do you align yourself with the attitude taken by Mr. Helens in terms of what should happen going forward from now on?
Indeed so.
Thank you.
Thank you.
Thank you, Mr. Chair. I'm Jaap Celia. I'm a senior counsel of the Pretoria Bar. I'm instructed by Mr. Stockenstroom Fouchier to act on behalf of Mr. Fana Shlongwane in this matter. We have received the 3 notices, but only on the 10th of August, and also in our instance, the statement provided as an annexure to the notice of Mr. Jonas was completely incomplete, in the sense that I gathered from the statement that at least 6-7 pages were missing and not sent through to us. But also, we don't want to complain. We also align ourselves with the sentiments expressed by Mr. Helens in this regard. If we can have the opportunity to discuss the matter with the legal team and arrange times in order to be provided the opportunity then to prepare for cross-examination of Mr. Jonas. Because at this stage I can indicate to you, Mr. Chair, that my instructions are that Mr. Shlongwane indeed want to participate in these proceedings, at least at this stage to cross-examine Mr. Jonas, and thereafter to take a decision as to whether he deems it necessary to testify and will call witnesses, as you indicated he may be entitled to. So, but for purposes of the procedures to be followed, we align ourselves with the views expressed by Mr. Helens, as you please.
Thank you, Mr. Celia.
Thank you, Mr. Chairperson. My name is Muzi Skakane. I'm a senior counsel from the Johannesburg Bar, Victoria Mukanya Group. I'm with Mr. Masugu SC and Mr. Bilo Skakane. We all representing Mr. President Jacob Gedlehlekisa Zuma. Chairperson, we rise. Our position is slightly different, as we discussed in your temporary chambers, in that while we seek an opportunity to respond to the Commission in terms of 3.4, the application we wish to make today is in terms of 3.5, which of course requires that we be given sufficient opportunity. And that, I'm starting at the end, that is the opportunity we seek, and it's in terms of that rule that we make this application. But having said that, because I started at the end, we wish to make the following point, is that we have received 3 notices, and I appear on behalf of Mr. Zuma in relation to that notice, which is the notice which relates to Mr. Masego. The second one relates to Ms. Mento. The last one, which we got at 25 to 10 on Friday in the evening, relates to Ms. Williams. I mentioned the time because we want to make it clear that we do not want to delay this process, and to the extent that our learned friends have suggested a way forward, depending on the election we make, we have no intention of stalling that process. It doesn't matter what we elect to do. But the point I wanted to put on record, Chairperson, is that we received the notices on the 3rd of August. And those are notices in relation to Ms. Mento and Mr. Masego. And as I said, we've received the other one on Friday. But the issue really that has made this difficult for us is that we have raised questions, and those questions are not just further particulars, it's to obtain certain documents, because we want to make a meaningful participation in this process, this very important process. And so what we've asked are documents that we believe will make it easy for us to know what case we have to meet if we make the election, that the implications that the Commission makes on the statements are the elements about which we think we should, or the client thinks he should come here. And therefore, what we request, Chairperson, is that we be given time starting from today, because as I said, we got a 103-page document only on Friday when we requested further documents. And therefore, we want to place it on record that we will make no delays, we will cause no delays, but we want to be given time to make that election, whether to exercise Rule 3.4, which says we must make a statement. But we, unlike my other learned friends, we've not made that election because we require to know exactly what case to make. I do not have to repeat the documents that we've asked for. They are self-evident because this process is truly about getting the evidence, and it's not a process about any flimsy discussion at a coffee shop with a friend. It requires evidence, and we want to place on record a proper case.
Thank you very much, Mr. Skakane.
Thank you, Chair. My name is Welcome Lusenga. I come from the Pretoria Bar. I will be led by Similibala SC in this matter. I approach on a different footing in that I act for the former Minister of Public Enterprises, subject to confirmation of instruction, her Director General, and possibly the Chief Director. Unlike other speakers who have risen, our time.
You mean the immediate former Minister of Enterprises?
Ms. Lynn Brown.
Ms. Brown.
Indeed.
Thank you.
Unlike other persons who have risen before you, our client did not receive any notice, nor are we soliciting for any notice. Given the nature of the terms of reference, given the institutions that are being covered, which were in her portfolio, given the developments in other commissions outside of this one, it is likely that she may be implicated by the evidence that would be led by different witnesses on different aspects. To be able to exercise her rights fully, to make the elections that she needs to make, and if possible, refute any evidence that has been placed implicating her. We request that we, hopefully from today, be included in all correspondence relating to notices that have been issued or that are going to be issued, the summaries of the witness statements that are given to all other participants in this matter. As far as the participation is concerned, we, like the other legal teams, stand on that footing. We do not want to delay this matter. We will align ourselves in terms of the arrangement that let the evidence be led. Our cross-examination, if any, will be deferred to an appropriate time so that the commission times does not get wasted.
Thank you very much.
Thank you, Chair.
Thank you. I don't suspect that Mr. Malega, or there is still one more counsel.
Thank you, Mr. Chairman. Henry Cowley, counsel from Johannesburg. I'm instructed by McMinimum van Eysteen and Botha on behalf of Ms. Lakela Kwanda, the former PA to the former president. She's been implicated in the Mentor matter, and although we've received short notice, we also do not intend to uphold any of the proceedings, and we are considering a position in terms of Rule 3.4. Thank you, Chair.
Thank you very much. I don't suspect that, Mr. Malega, you have anything to say in response to what the various counsel have said. basically in terms of what should happen from now on in regard to them.
No, Chair, I don't have much to say except to ask you to note the following. That as far as we understand the rules and the regulations, no person has a right to cross-examination. And that whoever wants to cross-examine a witness who gives oral testimony before you, they must make an application to you. One requirement of that application is that they must file with the Secretary of the Commission a sworn statement indicating the extent to which they dispute the written testimony of the witness concerned. To the extent that it is now common cause as between us and our learned friends who represents the implicated persons now on record, they have now made an application that they would like to cross-examine those witnesses. And we're grateful to them that they're not going to interrupt the oral presentation.
Well, I don't think anybody has made the application as yet, but I have no doubt that they, or at least some of them, may be intending to do so in due course. What I understand to be the position is that they are saying, in terms of the rules, once their clients have received a witness statement that's alleged to implicate their clients, they have a certain period within which they must respond to that statement. And at least I think most of them are saying they received the notices. The notices they received didn't give them enough time to deal with that, because that's the first step after receiving the notice of witness statement which implicates your client. And I think what they are saying in effect is we need to consult and be able to respond to these allegations. We are not asking that proceedings be adjourned until we have done that. We think that it will suffice if the witnesses implicating our clients continue to give evidence, as long as we will be given an opportunity to read the transcript and then have an opportunity to cross-examine. Obviously, they will have to apply for leave to cross-examine, and technically they would only know whether they want, or their clients want to cross-examine once they have dealt with the issues that are on which their clients are implicated in the affidavit. So my understanding is they are not making the application now, but I think we can expect that they may well make that application after they have dealt with the first hurdle, namely a response to the witness statements that their clients have received.
I understand, Chair, so I would not raise that issue any further for the present purposes. All I wanted to put on record is that we have returns of services indicating when the statements were served on the implicated persons. I'm not going to raise the debate at the moment. It might become important, but just to indicate to you that the first set of notices were served on implicated persons, including Mr. A.J. Gupta, on the 1st of August this year, the 6th of August this year. And we may have a debate in due course about whether or not that is reasonable within the meaning of the rules. So I leave that issue for later debate.
As I indicated, I would be inclined to give persons or legal representatives who need time to comply with the rules in terms of responding to statements that implicate their clients, particularly when we are able to proceed while they do that. They have asked to be given a chance to consult with the Commission's legal team to see what may be agreed, which will be subject to my approval in terms of what time they should finish those responses. I think that the best way to deal with this is that since it's now 1:45, we should adjourn now for lunch earlier than would normally be the case, and the time can be used to discuss, for discussion between the, or part of the time can be used for a discussion between the legal representatives of the various parties with the Commission's legal team. And when we resume after lunch, then I can be informed of how far those discussions went. So I think that's what we are going to do. We would, I would say we need to come back at 2, but I don't know whether the 15 minutes before lunch, which we have now, and the lunch hour, or part of it, you counsel too must eat during lunch, whether that would be enough for the discussions or whether we should start a little later than 2 o'clock. I don't know whether anybody is able to indicate whether 2 o'clock will give you enough time.
Chair, can I suggest that we resume at 2 unless we inform you otherwise?
Very well. We will then adjourn until 2 o'clock.